Welcome to Stanford. My name's Mark Lemley, and I run the program in Law Science and Technology here. We are pleased to have you all here, and we're very much looking forward to an interesting talk from Andrew Byrnes. Let me just briefly mention a logistical announcement. Andrew's going to talk. We will have time for questions, but what we ask you to do is, and this is going to sound just insanely old-fashioned, write your questions on a note card. You will see note cards circulating, and two of our fellows here, Dimitri and Nicole, will circulate and pick them up. Dimitri and Nicole, you want to stand up and... so they will come by and give you note cards. They will come by and pick up the note cards to ask the questions. If you have lost the ability to actually write not using a computer, I apologize. It's one of those things that happens in Silicon Valley. All right. I am delighted to welcome back to Silicon Valley and back to Stanford, his undergraduate home, Andrew Byrnes. Andrew is the Chief of Staff of the U.S. Patent and Trademark Office, which, while I think this is not the official role, means he's the person in charge of making sure that things actually happen. And that seems to me a particularly important job in the Patent Office in this day and age. He came to the Patent Office from the law firm of Covington and Burling here in the Valley. So he has experience as an intellectual property lawyer. He's also been active in politics, and in fact, he and I met on the Obama campaign very early in the Obama campaign, I think. But most interesting to me, he's also a producer of an award-winning documentary film called The Power of Two, which if you haven't seen, I recommend. And so we have with us a man of many talents, and he's going to talk about Silicon Valley and Washington, D.C., and what you can learn moving back and forth between them. Andrew.
Thank you. Whenever I hear Mark speak, and thank you for that introduction, I always think, why didn't I have a teacher like that in law school? But thank you, Mark, for that. I also want to thank Stanford Law School, in particular the Program on Law and Science and Technology, the American Constitution Society, the Silicon Valley Intellectual Property Law Association, the Silicon Valley Directors Exchange, and the Stanford Rock Center for Corporate Governance for helping put together this event. It's fabulous to see you all here. It's fabulous to be back here in Silicon Valley and to see so many friends, former colleagues, and I think a few litigation adversaries in the room today. But they're all smiling, so I think it's all good. It's been a year since I joined the President's team as Chief of Staff at the U.S. Patent and Trademark Office. And suffice it to say, it's been a very intense year, and a stark reminder that snow and oppressive humidity are real things and not just something you see on TV. Now, my time in Washington thus far has been an exhilarating opportunity to expand my work at what I call the intersection of technology, law, and politics. Now, I wasn't the first one at this intersection. In fact, Professor Lemley, I think, beat me to it, but it's really amazing to see how crowded that intersection has become. Now, intersection, or IP, as we call it, including patents, trademarks, and copyrights, is no longer a topic reserved for a small group of highly technical or specialized scientific people or lawyers. IP now permeates all fields of interest, all layers of society, and all parts of our daily lives. Now, as IP has become more prevalent and important, the debate about how to ensure that the patent and copyright systems continue to, quote, promote the progress of science and useful arts, as the Constitution provides, has never been more fervent. Now, wherever one comes out in that debate, there can be no debate, in my view, on these fundamental points. The first, that the novel ideas and creative works protected by strong IP rights have the potential to drive the state-of-the-art forward by leaps and bounds. And second, and even more, that the protections afforded by those rights can attract the critical resources required to take new inventions and creations to the market. And that's why we at the PTO, the Department of Commerce, and the Obama administration are working aggressively to ensure that America's IP system is balanced, keeps up with technological advancements, and is poised to fuel the creation of good jobs, promote competitive markets, and sustain an economy built to last throughout the 21st century. Now, some of this may shock some of you, but when I first arrived at Stanford in September of 1990 as a freshman, and I was in Wilbur, Soto in particular. I did so without a computer. I had brought a word processor from home. I think it was a Brother word processor. And I wrote my papers on that word processor, and when I got a little bit more advanced, on an Apple IIe computer in the dorm computer cluster. I played meticulously, and I have to emphasize that, meticulously curated mixtapes with songs I taped off the radio on my boombox, which was a prized possession for many years. Now that year, in 1990, fewer than 100,000 US utility patents were issued and 911 patent infringement lawsuits were filed. Now in 1997, fresh from my post-bar road trip throughout the Midwest, and newly arrived as a litigation associate at the former Heller-Ehrman law firm, I was assigned to my very first patent infringement lawsuit, which was one of about 2,000 or so brought that year. I wrote my briefs then on a Gateway 2000 computer using, of course, WordPerfect, which if you haven't had the experience of using, I highly recommend it. I was still using that same boombox, although not so much because it was state-of-the-art, it's just that I'm really cheap and I refused to buy something new. Now in 1997, about 110,000 patents were issued. In 1999, at the height of the dot-com boom, the first BlackBerry pager, TiVo DVR, and Wi-Fi devices hit the shelves. And for my part, I wore a large, uncomfortably so given our standards today, mobile phone holstered on my belt for all to see. So clearly I was a 21st century man, even in the 20th century. Now, like everyone else, I used the internet, of course, to learn about technologies and people involved in my cases, look at stock quotes, sports scores, and news stories. The year before, in 1998, the Digital Millennium Copyright Act had been passed, establishing safe harbors that limit the liability of internet service providers under certain circumstances, including when they act responsibly in hosting copyrighted content posted or transmitted by their subscribers, which enabled me and millions of others to readily access useful content on the web, and perhaps equally important, lots of completely useless content as well. 1999 was also the year of the first complete sequence of a human genome, which I mentioned because perhaps compared to some of these other inventions, this one is even more profound, but that would have seemed science fiction not too many years earlier. Now, of course, those of us who are children of the 1980s took special joy in 1999 in the fact that 17 years after Prince released the song, it was finally time to party like it was 1999. Back to IP, though, in 1999, the 6 millionth US patent was issued, just 8 years after the 5 millionth. And there were 2,200 patent infringement lawsuits, over twice the number as a decade earlier. So let's fast forward to 2011. My boombox had been displaced by a portable media player, which stored my entire music collection, and the device fit in the palm of my hand. Now, of course, it couldn't tape songs off the radio, but I had switched to satellite radio anyway, so it didn't so much matter. My smartphone weighed much less than my first mobile, gargantuan, but mobile phone, and about 1/300th as much as my old computer, with a processor 7 times as fast, and covered by roughly 250,000 patents, according to some reports. And perhaps not surprisingly then, in 2011, the 8 millionth patent issued just 5 years after the 7 millionth. And at the same time, the number of patent lawsuits had skyrocketed now to over 4,000, over 4 times the number 15 years earlier, as did the cost of defense of such a suit to the tune of about $2.5 million a pop, and sometimes a lot more. More companies were being sued for patent infringement that had rarely, if ever, had anything to do with patents, such as restaurateurs and retailers. The discussion about patents and patent litigation became the talk of CEOs in the mainstream press, not just of technologists and the patent bar. Public radio's This American Life produced an hour-long segment on patent litigation. And presuming that NPR, like every other broadcaster, actually tries to figure out what their listeners want to hear before they put it on, that meant that there were enough people in this country getting NPR who wanted to hear about patent litigation for an hour. That is a big change, folks, a big change. And the smartphone wars, as they're called, were chronicled on the front pages of the Wall Street Journal and the New York Times. Now, an increasing number of these suits were brought by patent assertion entities, whose sole business is enforcing patent rights, and that don't necessarily use the patented invention to make any product or provide any service. Now, against that backdrop, in 2011, President Obama signed into law the Leahy-Smith America Invents Act. Now, as I've learned, nothing is real in Washington until you give it an acronym. And as those of you who have spent time in Washington can relate, and this law, of course, became known as the AIA, America Invents Act. The AIA effected a sea change in aspects of U.S. patent law, including aligning the U.S. with the rest of the world by awarding patents to the inventor who is first to file a patent application, rather than the first to invent. The law also empowered the PTO to keep the fees it collects from patent and trademark applicants and from trial and appeal board petitioners. As a solely fee-funded agency which takes no tax dollars, the PTO is dependent upon those fees for our operations, including fast-tracking patents and bringing our IT systems into the 21st century. The AIA also established new post-grant review proceedings intended to streamline patent disputes, making them more efficient and less expensive. Now, running up to and even after passage of the AIA, more and more questions were being asked about the state of our patent system, about whether it had kept up with the changes in business and technology of the past several decades. And many of the same questions were being asked about IP and its impact on business and society of the copyright system, particularly as technological changes transformed the ways in which consumers of creative works read, viewed, and listened to them. New technologies also meant that it was easier to create and, in many cases, copy those works. And IP transformations in recent decades aren't limited just to patents and copyrights. Particularly with the development of the internet and the expansion of advertising and distribution pathways globally, branding, and importantly, trademark protection of a brand is critical. Now, thankfully, filing a trademark application is easier than ever, with revolutionary improvements to PTO and IP offices around the world to enable electronic filing and harmonized filing requirements, so much so that new filings have increased about 240% over the time period. And especially notable for those of us in the Bay Area, filings in the wine and spirits class have increased dramatically from 1,400 17 years ago to over 8,000 applications in 2013. So the next time you're in cocktail conversation, I'll hope you pull that tidbit out. So there's little doubt that IP and the industries it supports have a significant impact on the economy. A 2012 Department of Commerce study found that industries that most intensively use patent or trademark protection, or are primarily responsible for the creation and production of copyrighted materials, account for almost 30% of American jobs and over 60% of merchandise exports. But more than an economic driver, protecting IP in a balanced and effective way is also critical to good government and core American values of equal opportunity and justice. Now, as I mentioned before, the Constitution grants Congress the power, quote, to promote the progress of science and useful arts by granting to inventors and creators an exclusive right to their inventions and creations for a limited time in exchange for public dissemination of those inventions and works. The IP system recognizes that providing incentives, particularly economic incentives, is the best way to encourage people to focus their attentions, talents, and resources on a particular task. The incentive of exclusive rights for a limited time has proven over the years to be a very powerful one. As President Lincoln, the only president who ever held a patent, said, "The patent system added the fuel of interest to the fire of genius." Now, of course, there are other incentives as well. For example, the PTO's Patents for Humanity prize competition rewards innovators who deploy game-changing technologies to meet global humanitarian challenges. Winners can expedite select proceedings at the PTO and receive public recognition. So if you have a patented invention that's making a difference globally, I encourage you to apply for this year's competition before the new extended deadline on October 31st. Now, our patent system is democratic with a small d, and empowering. Anybody can come up with a novel idea. And if you do so, when you obtain a patent, the patent system has your back against those who would try to use what you've patented without your permission. And I'll discuss in greater detail later how the USPTO is working hard to expand access to the patent system to all inventors, regardless of their resources. Now, our copyright system, protecting creativity of a different, although sometimes related sort, is perhaps even more democratic, again, with a small d. More than ever before, content creators ranging from individuals at home to large corporations are able to create or distribute multiple perfect copies of creative works seamlessly and without regard to national borders. And copyright registration is a relatively simple and inexpensive method for one to protect their rights. The conviction that anyone from any station in life can be an inventor or creator and make a living, even a fortune, from their invention or creation runs deep in our American spirit and beyond our borders to many throughout the world. Ensuring that law and policy are aligned with that spirit, that Americans are given equal opportunity to invent and create, and that our system of justice will support them is my conviction as an American and my commitment as a public servant. I took my appointment from the president last September, leaving Silicon Valley for the nation's capital, and found myself, as I said earlier, in the middle of that intersection of technology, law, and politics, albeit on a much larger scale. So as someone asked me when we were out at the reception, what exactly is a chief of staff? And I really liked Mark's description. I'm going to try a little bit of a different one here. So journalist John Baldoni has described chief of staffs across organizations as the leader's champion, administrator, confidant, and organizer. Others have called the chief of staff a gatekeeper, although as a fan of the movie Ghostbusters, I tend to prefer keymaster. Regardless of what you call me, as chief of staff, I'm the principal advisor to the head of the PTO, who's Deputy Director Michelle Lee, helping run our 12,000 employee $3 billion agency and managing our policy coordination and external outreach and engagement. At its core, my job is to help ensure that the USPTO is achieving its mission to optimize patent and trademark quality and timeliness and provide leadership to improve IP policy, protection, and enforcement worldwide. And that includes not just patents and trademarks, but copyrights and trade secrets as well. To do so, I work hand in hand with the PTO's leadership team and colleagues at the White House, Department of Commerce, and the federal government as a whole, as well as the innovation community globally. Now, while my role as a chief of staff is not a legal one, my background and perspective as an attorney comes into play daily. Now, I became an attorney even though I didn't know a single lawyer before I went to law school. Now, sometimes people say I became an attorney because I did not know a single lawyer before I went to law school. But be that as may, I became an attorney because I knew that there was a system, a set of institutions and rules that helps order our society. I also knew that there's a difference between making things happen and having things happen to you. And I knew that my better understanding the system would not only give me the power to pursue my own course, but the ability to help empower others. And I know that many of you here today share that same view. The commitment of the legal community to take action beyond itself, a commitment lived out every day by many of the groups and individuals represented here, provides a critical opportunity for attorneys to make a broader impact beyond achieving good results for their paying clients. Now, I focused my career in IP due to a perfect storm of interest, opportunity, and geography. My interest in technology and its impact on society and business started even before I was in high school. And as I said earlier, when I graduated from law school, patent lawsuits were on the rise, and general practice law firms like the one I joined were building their patent litigation practices. And of course, in Silicon Valley, IP is as much a part of the culture as hiking in the foothills, cheering for the Giants to move on to the World Series and Hobie's coffee cake. But I want to speak briefly to the law students and junior lawyers in the audience who are interested in IP, but have doubts or have been dissuaded because they do not have a college degree in a technical field. While a technical degree is required to be a member of the patent bar, IP litigators and copyright and trademark practitioners do not need technical training. Many of the most successful patent litigators, including some in this room today, have degrees in the social sciences and humanities. And that's a good thing. Because just as IP pervades our society and helps drive our economy, the IP legal community should, in fact, it must accommodate the talents of interested, committed attorneys regardless of their degree. And remember, members of juries and judges, with the exception of patent, trial, and appeal board judges, are very unlikely to have a technical background at all, let alone one directly relevant to a particular case. So a good IP lawyer needs to understand not only the technical issues in a case, but also how to explain those issues to those with little or no technical background. So if you're a quick study, can work with colleagues and experts to get up to speed on the technical issues, and have good lawyering skills, don't give up your IP aspirations. I'm certainly glad that I didn't. So people often ask me how I found this transition to public service from private practice. On the one hand, it's been a pretty big change, other than the weather and so forth. The diversity of issues and breadth of impact that's part of my daily life as chief of staff is far greater than in my former role as a patent litigator. A day may start out with a briefing on the World IP Organization General Assemblies in Geneva and finish with an interagency meeting at the Department of Commerce talking about copyright issues, with discussions of budget, managing our satellite offices, and our patent quality initiative during the day. I'm learning an entirely new set of rules, regulations, and bureaucratic idiosyncrasies. And I'm wearing ties every day. Not to mention the occasional pair of long underwear during the winter. I am not in Silicon Valley anymore. On the other hand, my transition to public service has not required a big change in my focus. Through my work in the community, in philanthropy, and in politics, as well as through pro bono matters in civil rights and other areas, I've always set my sights on making a broader, positive impact. But there's no question that today I look at my role and my purpose very differently, because now my client is the American people, and they are as engaged and demanding as any paying client I ever had, as they should be. And it's just as important to listen to what they have to say. It's just as important to be a loyal and zealous advocate for their interests. And it's just as important to get it right. Now, during my tenure thus far, patents have been the primary IP focus in policy at the PTO and in the administration, specifically whether and how to reform our patent and patent enforcement system. Now, the Constitution provides for a patent system, as I mentioned earlier, but that provision is not self-executing. It gives Congress power, but it doesn't tell us what patent law should look like. So the patent system we have is the result of decisions made by Congress, the administration, and the courts, each attempting to strike the right balance between rewarding the risks that inventors and their backers take, and protecting consumers and competitors from misuse of the patent holder's exclusive rights. In other words, so that the system's benefits outweigh the costs. Although much of the attention recently has been given to legislative efforts at reform, we can and should ensure that the patent system is balanced and effective through multiple ways: legislatively, through congressional action; judicially, through rulings by the courts; administratively, by actions taken by the PTO and other agencies; and of course with input and action from all of you. Now, fewer than 18 months after the AIA passed, during a Google Plus fireside hangout, speaking of technological advances, President Obama was asked about the impact on high-tech startups of demand letters and patent lawsuits by patent assertion entities, sometimes called patent trolls. He responded that the AIA had made progress on some issues, but that, and I quote, "our efforts at patent reform went only about halfway to where we need to go." So what's left is changing the economics of patent litigation to address the problem of abusive patent litigation. While not the only challenge facing our patent system, addressing this issue is imperative. Now, right now, a complaint doesn't require much detail, so it's relatively inexpensive for a plaintiff to file one and initiate a lawsuit. However, for most operating companies, that is, companies that develop and sell products and services, there are strategic considerations to evaluate before sending a demand letter or filing suit, such as the possibility of patent counterclaims that you'll be sued back for patent infringement, disrupting relationships with suppliers and partners, and triggering the mutually assured destruction of legal department budgets that discovery has become. Now, patent assertion entities are different because they don't have those strategic barriers to filing suit. They don't have to worry about being sued for patent infringement. They don't have relationships with suppliers and partners, and rarely have much to produce in discovery. But for defendants in a patent case, the costs are immediate and significant. I don't have to tell this audience how expensive it can be to have a law firm review a complaint in the patents in suit and do a preliminary analysis of potential defenses and damages. And of course, let's not forget about discovery. Believe me, after 16 years as a patent litigator, I think about discovery in my sleep. And I'm in therapy for that, but let's not get into it here. In any event, a defendant will have to review and produce documents related to the allegedly infringing products or services, and additional documentation relating to damages. And that's to say nothing of the cost or distraction of depositions, and we haven't even started talking about expert witnesses yet. I know there are a few of you in the audience. And as you know, if you've stayed up for days preparing, working with witnesses, and eating several thousand calories of red licorice, and those mini candy bars, and telling yourself, this has nuts in it, it's good enough for a dinner. It costs even more to go to trial. So the average big case with over $25 million at issue costs about $5.5 million on average to defend. And a small case with about $1 million or less at issue costs $700,000, which means that the cost of defense can amount to 70% or more of the exposure. So it's no mystery why there's pressure to settle even if the case has no merit. Now, of course, going to trial isn't costless for the plaintiff. Earlier in my career, I've gone to trial both for patent holders and accused infringers. But some patent assertion entities build their business around the idea that they can send hundreds, if not thousands, of vague demand letters to companies who will do the math and pay for the license just to avoid litigation. Now, reasonable people may, and in fact do, I know, differ about the effects that different proposals for reform might have on the patent system as a whole, or even whether we need to do anything non-judicially. And certainly on the judicial front, there have been important developments. In the Supreme Court's last term, the courts made it easier for district courts to award attorney's fees to prevailing parties in patent cases. It's adopted a higher standard for claim clarity, and in CLS Bank laid the groundwork for more aggressive challenges to certain categories of patents, such as business method and software patents. But for my part, I think it's possible for those of us in the executive branch as well as the legislative branch to take positive steps to correct this imbalance in the system while still providing inventors with the incentive to invent and patent owners with the ability to enforce their patent rights appropriately. And as I said before, fixing this imbalance is just one part of the puzzle, but it's an essential part, because the last thing we need as our economy gains traction again is for researchers, inventors, and small businesses to be distracted from innovation by litigation. Now, building a patent system that remains effective and balanced as technology continues to transform at a rapid pace demands that we look at the system as a whole over the long term. It also demands that we not stand still and wait in the hopes of reaching a legislative solution. And that's why we at the USPTO are redoubling our commitment to issue the best quality patents possible. While quality's always been our #1 goal, there are new opportunities provided by the AIA in that it allows us, the agency, greater access to the fees we collect. We're making progress toward our target pendency and backlog goals for patent applications. And then the increasing attention to patents as well allows us to focus even more on quality. Now, our Enhanced Patent Quality Initiative, which was announced about 2.5 months ago in a room just downstairs from here by Deputy Director Lee, is the most ambitious in the agency's history. In part, the initiative leverages a number of administrative actions put forth by the White House designed to protect innovators from frivolous litigation, strengthen our patent system, and foster innovation. We're working to increase the level of scrutiny given to proposed patent claims that may be too broad, to optimize the quality of patents, particularly software patents. We're providing targeted training for patent examiners, including 4 new training modules related to functional claims. We've launched a pilot project that allows applicants to use glossaries in patent applications to define terms, leaving no doubt to the examiner or, in the future, judges, juries, or litigation adversaries what the words in the claim mean. We're making it easier for companies, experts, and the general public to provide more relevant prior art to the PTO. We're refining our existing third-party prior art submission program, exploring other ways for the public to submit prior art, particularly non-patent literature, and updating our guidance and training for examiners to more effectively use crowdsourced prior art. By encouraging the innovation community to uncover and submit hard-to-find prior art, we're actively enlisting the innovation community in our pursuit of quality. We're also expanding our patent examiner technical training program, which ensures that experts in industry and academia can provide relevant technical training to our patent examiners, whether at our headquarters in Virginia or at one of our satellite offices. And this is another area where you can have a direct impact on the quality of patents we issue. There are outside on the table, I believe, still some brochures about that program. And if you're in a company or here at Stanford and would like to help train our examiners on the latest technology, please contact us. Now, speaking of satellite offices, although our Silicon Valley satellite office is in temporary space in Menlo Park until we open in San Jose City Hall next spring, we have 19 patent trial and appeal board judges on site, and we're actively engaging with stakeholders across the Bay Area and beyond. The head of our Silicon Valley office, John Kebeka, is here today, and he will be our on-the-ground connection between you, the innovation community, and the PTO. So John, will you give them a wave? Thank you very much. He's doing a fabulous job and enjoying the weather while I suffer in DC. But I'm not holding a grudge at all. We're also helping to make sure that under-resourced independent inventors, startups, and small businesses are able to access the PTO by providing dedicated resources to pro se applicants who lack legal representation and working with our partners nationwide to expand the AIA pro bono program. Assistance from the PTO or from a patent attorney can be critical in preparing the necessary documents to help ensure that if an invention is patentable, a quality patent is issued as quickly as possible. So if you're a patent prosecutor, I strongly encourage you to lend your skills to inventors who could use your help through the California Inventors Assistance Program, which is run by the California Lawyers for the Arts. I believe that all the brochures I put out have been taken, but you can learn more at calawyersforthearts.org. We also have a number of other key initiatives that help facilitate quality. First, our recently created Office of International Patent Cooperation is working closely with other patent offices around the world to create and expand automated tools that enable examiners to share prior art, making it more efficient to obtain patent protection worldwide. We're making necessary investments in our IT infrastructure to ensure that our 21st century agency has up-to-date IT systems. Our next generation systems include our comprehensive Patents End-to-End project, which is designed to streamline patent prosecution from application to issuance. And speaking of data, we collect a lot of data during the patent examination process, and we'll be able to collect even more once Patents End-to-End is up and running. We want to take the lessons we learn from that data and feed them back into the earliest stages of examination in order to improve quality from the first touch of an application. Over time, we plan to analyze data at every operational level, not just to increase quality, but to strategically deploy resources and manage our agency even more effectively. But data are not only for our agency's internal use. They are the fuel that powers today's economy. And we recognize that making the PTO's data more accessible to the innovation community not only supports the administration's goal of transparency, but it also will lead to greater understanding of what we do and empower third-party innovators to create new, useful products and services utilizing the data. Perhaps most importantly, we want to hear from you, our stakeholders, about how you think we can ensure and measure patent quality. This fall, the PTO will host a patent quality roadshow to share with our stakeholders more details about our patent quality initiative and to receive your input on what we can do better. The tour will definitely come through the Bay Area, so please stay tuned for more information and plan to participate. Now, our job isn't done even when the patent issues. The validity of an issued patent can be challenged through an administrative patent trial held by our Patent Trial and Appeal Board, or PTAB. Since September of 2012, the number of filings of petitions has grown from 0 to over 2,000, many more than expected. Let me put it this way. If the PTAB were a federal district court, it would be the #1 court in patent filings. As a marker of the value of those proceedings, the Court of Appeals for the Federal Circuit recently overturned a district court's failure to grant a stay in favor of a PTAB proceeding. The court cited the value in the PTAB's resolving the parties' dispute and determining whether the patent was valid in advance of a district court opinion. So as we strive to ensure that the patent system works for innovators, for those who hold patents and those who don't, for those who are asserting infringement and those who are accused of it, as well as for the public as a whole, there's no silver bullet. There's no single step by Congress or by the PTO or by the courts that will bring the system into perfect alignment and keep it there. But I'm confident that all of us working together can and will keep the system effective and balanced and a force for innovation. Now, ultimately, the key to building this stronger, more consistent, and more nimble 21st century IP system requires the engagement of people who will live and breathe the consequences day by day. IP practitioners, the broader business and legal community, all of you here today. That engagement, that conversation with all who are in the IP system is a priority for the PTO and the administration. It's a conversation that helps identify and define problems and potential solutions. It's a conversation that we've been having since well before I arrived, and it's a conversation that will continue well into the future. Now, before I came to DC, I thought that having a seat at the table was a metaphor rooted in some historic practice, like from the King Arthur days, right, to the round table. But I've learned that in conference rooms throughout Washington, there actually is a table, and that having a seat there means that you're part of the conversation among those who will influence the decisions that are made. Now, at the same time, while there are seats at the table, there are just as many seats not at the table lining the walls of the room. And if you're in one of those seats against the wall, you're most definitely not at the table. Now, among those of us in government, there's an unwritten protocol about which of us gets to sit at the table versus against the wall at any particular meeting. Now, I'm from the Valley, so I always sit at the table because that's just what we do. But our DC colleagues are not similarly minded, and there are probably some meetings that maybe I would get in trouble, but I haven't yet. But the important point to be made is that as a private citizen, each of you, individually or through an association of people, can literally have the seat at the table. Now, I make this distinction not because I spend a lot of time thinking about seating arrangements, and in fact, my wife barred me from thinking about that after our wedding. But I make the distinction because it's a helpful illustration of what engagement in this process looks like, because there's a difference between commenting on the process from the outside and being a part of it. And I bring this up here in particular because there are voices in that room in DC, and perhaps even in this room here at Stanford Law School, that aren't at the table, that have deep experience when it comes to IP and innovation, and the ramifications of each of them in the real world. So to each of you, I'd say, be part of the process and join us at the table. Taking that seat requires effort and engagement, to be sure. But whether you engage by responding formally to a request for comments or Federal Register notice, participating in one of our many topical roundtables across the country, or relaying your views more informally to us or other policymakers, your participation matters. We and our colleagues across the government are listening. Now, to go back to the question then, how have I found the transition between private practice in Silicon Valley to being chief of staff at the PTO? Well, for one, I've come to appreciate how intertwined technology, law, and politics really are, even more so than I appreciated from my vantage point here in the Valley. A lesson I've taken from my experience thus far in government is that there's nothing automatic about innovation or the laws governing innovation. There's not even a consensus about what innovation really means, although that's a topic for a different speech, and maybe I'll do it here next year. But what we have today is the result of choices we've made about how best to foster innovation, including striking the right balance between rewarding inventors and creators and enabling the next generation. And as the pace of technological change accelerates, we have to revisit old choices and make new ones to ensure that the next big thing isn't governed by a patent system that was designed for my word processor back in Wilbur Hall here at Stanford, or a copyright system of the boombox and VCR era that doesn't account for the amazing new pathways that technology has blazed for creating and disseminating creative works. So from our perspective today, the intersection of technology, law, and politics in 1990, when I arrived here in the Valley, seems quaint, like a meeting of country roads in the Central Valley. Now today, that intersection seems more like the 101 in 92, or maybe the 101 in 84, maybe more the 101 in 280. Well, the 101 in pretty much everything, because it's crowded and it's sometimes complicated. But it's an essential part of the path of where you want to go and where we need to go as an economy and a society. So I left my home in Silicon Valley to come to Washington, at least for a time, because I believed and still believe that this is an all-hands-on-deck moment for innovation and IP in this country. The issues are too important, the timing too critical, and the impact too great. Now, you don't have to change jobs or move across the country as I did. But if we're going to navigate through this intersection to a better IP system, it's going to take all of us sitting around that table working together. Thank you very much. So
all right.
I'll be taking questions.
Great. So I'm Roland Vogel. I'm Executive Director of the Stanford Program in Legal and Informatics and Stanford Program in Law, Science, and Technology. So I have the honor to read your questions.
Great.
The first one is, can you please comment on the recent Myriad Genetics decision and recent changes to the patenting of genetic material?
Okay. So just a bit of background. I know we have a variety of folks here with different areas of IP and legal background. So Myriad is a recent Supreme Court case that addressed the patentability of certain subject matter in the life sciences. So I think I'm probably best suited to address that question in the context of what we at the Patent Office are doing about the Myriad decision. So as a matter of process, when the Supreme Court comes out with a decision that speaks to patenting, what's patentable, we prepare guidance for our examiners. There are 8,300 patent examiners across technologies. And we prepare guidance documents so as they're looking at some 500,000 plus applications a year, they can evaluate whether, in fact, that patent, that the subject matter of the patent is patentable, potentially patentable. So we came out shortly after the Myriad guidelines. The Myriad case came down. Actually, I should strike that. It wasn't shortly after. Roughly a half year after the Myriad case came down, we put together initial guidelines for our examiners on the case, and then took a substantial amount of input from the innovation community about those guidelines. And there were many questions that were raised about, okay, well, these are the guidelines. What happens if I have this fact, if my patent claims this fact pattern or that fact pattern? So we are evaluating those comments and intend next month to come out with revised guidance, which accounts for a number of the key points that were raised. Some of it is in the context of providing more examples of what is patentable and what is not, but we're also addressing substantively some of the points that folks raised. So this is a key, obviously it was a key and very important decision that the Supreme Court arrived at, and we want to make sure we're faithful to it.
Great, thank you. So the next question is, could you please address how the PTO might distinguish between patent assertion entities and non-practicing entities? Is it like research centers or universities? Is that
Sure. So for a little bit more background for folks in the audience who are less familiar with this, with patent litigation. So I talked in my talk about patent assertion entities. These are entities that hold patents, and their primary business is to assert the patents against alleged infringers. Non-practicing entities, or so-called NPEs, is a broader superset of entities, sometimes including universities, researchers, and others who own patents as well and simply don't practice them. They may or may not assert them, but they don't practice them, so they're non-practicing entities. In the PTO, from an operational standpoint, we make no distinction between PAEs, NPEs, or other applicants or patent holders. The issue comes, to the extent it comes into play at all, is in the context of policy discussions. We are less focused on who the patent holder is and more about the actions of the patent holder. So when we talk about abusive patent litigation, we're not so much talking about who the plaintiff is per se. We're talking about the activities that that entity is engaged in. So the nuanced distinction between PAEs and NPEs is not a significant one, either operationally or in many cases from a policy perspective.
Okay, great, thank you. So yeah, unfortunately, Director Byrnes has a hard stop at 7 o'clock, so we only have time for 2 more questions, even though that a lot of great questions.
I will try to be brief so we get more in, yes.
So the next question is, I've read that 90% of claims are found to be invalid in inter partes review. Those are issued patents. Is this an overreaction to trolls?
There's a lot in that question. I'm not sure I can be too quick. Okay, so I mentioned in my speech about post-grant review proceedings. This is an opportunity for third parties to come to our Patent Trial and Appeal Board under certain contexts and say, hey, that patent that was issued, it's invalid. And this is a very broad brush of what it is. But and in those proceedings, which have been, those are the ones that were 0 in September 2012, now there's 2000. Many of the patent claims, the patents in those proceedings have been found invalid thus far. So for a couple points I would make. One is, I don't think, the question about whether it's an overreaction to trolls is, the answer is no. I think the legislation that produced those proceedings could have been in part in reaction to so-called trolls. You'd have to ask the legislature about that, but the Congress. But I think the fundamental premise of the IPR proceeding is that there are some patents out there that, yes, they went through the process and were issued, but they're commercially important patents, and now litigation adversaries and others are spending much more time focused on their validity than the PTO ever could, and they're looking at prior art, some of which may not be available to the patent office. So the fact that 90% of patents through this IPR process thus far have been invalidated, and I don't know if that's true, but I'll assume for the purposes of the question, or the answer it is not particularly a surprising one. Our PTAB, our administrative patent law judges, are calling balls and strikes as they see them, but because of the process, it is about it's although cheaper and faster than litigation, it's a litigation-like process. And so adversaries are putting lots of time and money and effort into trying to invalidate those patents. And it's not a surprise to me. I don't think it's an overreaction, but I think over time you'll see that many patents that perhaps shouldn't have been issued will be invalidated and others will be upheld and will be gold-plated or potentially gold-plated from a litigation perspective after that.
Great. So the next question, actually, two related questions. So we'll make it into one. So first, what are the metrics which you'd use to assess the intent of the American Invents Act? And sort of as a related question, what are the prospects for patent reform legislation this year or in 2015?
Okay. So the first question is, how do we know the intent of the American Invents Act?
Which are the metrics you'd use to assess the intent of?
Okay.
Measure the.
Oh, the measure of the success. Oh, I'm sorry. So it's not about intent, it's about success. Oh, okay. Well, the American Invents Act is multifaceted, and I don't think we'll know its full impact for quite some time. But in terms of the, but focusing on the patent litigation piece, in particular these inter partes review and other post-grant review proceedings, if success is to be measured by the demand in the innovation community for the proceedings, then I think we can consider them a success thus far. They're in tremendous demand, and you know, I think from speaking with colleagues who are patent litigators, bringing a challenge before the PTAB. I know we have a couple of judges here today from the PTAB, has become part of a comprehensive strategy of defending against patent infringement, because we have technically trained judges who are just amazingly qualified and at the top of their game looking at these patents and giving them a close look. With regard to other aspects of the AIA, such as the move from first to invent to first inventor to file, I think that will take a little bit more time. But the mere aligning ourselves with the rest of the world in terms of our patent system, I think is a step in the right direction. And finally, in terms of the prospects for patent reform, it is far be it from me to be the one to handicap that. I will say that there's precious few legislative days left in this Congress, and it would be, I would say you could probably make a pretty healthy profit if you were to bet that, if you were to guess successfully that it would happen in that time frame. I think it's unlikely. There's also a window after the election before the next Congress takes over. But I think the conventional wisdom is that probably patent reform legislation, if it happens, will be in the next Congress. But you know, from my perspective and from our administration perspective, we do believe that legislation is a critical part of reforming the patent system and bringing it into a balanced and effective state.
All right, thank you.
Thank you.
So yeah, so we have lots of great questions, and unfortunately we don't have time to get to all of them. But maybe the final one would be,
sure.
Andrew, if you had a magic wand, what would you most want to do to ensure that Specious patent suits couldn't be attempted?
If I had a magic wand, what would I most?
What would you want to do to ensure that Specious? So
Specious. Oh,
excuse my.
So how to discourage or prevent specious patent lawsuits? Well, first, kudos for using specious in your question.
Tripping the non-native speakers up.
No. And it's, you know, you're at Stanford, right? You're going to get words like specious. That's great. You know, as I said in my speech, I don't think there's a silver bullet. So there's a range of components of reform that the administration has supported, including expanding access to attorney awards of attorneys' fees for prevailing parties under exceptional circumstances. Providing more information to less knowledgeable entities that are facing patent infringement demand letters or lawsuits. There's a lot of different components. And I don't think I could isolate one that would sort of be a silver bullet, but I think there's a range of them. And as both the legislature, Congress, the PTO, and the courts sort of move along, and the court develops more case law, and we at the PTO continue to improve our patent quality, our data and do other things that really makes the patents even stronger. I think each of those working together will get us to the right place, but I don't have a specific silver bullet in mind that will solve the problem. The good news is, one, that there are a lot of people focused on it, and two, that I hope you'll all join us again at the table and help discuss how we can work together to limit specious patent litigation and more generally ensure that we have a balanced and effective system. Now, before I leave the stage, I will not drop the mic because I don't own it and it'll probably cost money, although the dramatics might be nice. I'm going to write my contact information on the board. So to the extent you asked a question and it wasn't among those I see pretty large stock that wasn't answered, or you have more generally would like to communicate with me about the office or want to exchange mixtapes, I'm open to all of it. So, but thank you all very, very much for coming out. I really had a great time.
Thank you very much.